I'm going to take you through two potential claims in the tort of negligence. Firstly, Tony. I think he has a legitimate claim in negligence, unless the high threshold can be met for Dr. Riff to be liable under novus actus interveniens. The maximum amount Tony will be able to claim for is £118,000, according to the Judicial College Guidelines for the Assessment of General Damage in Personal Injury Cases. I believe Maria will be successful under a personal injury claim in the tort of negligence, as it will be very difficult to prove the BBC was unaware of asbestos risks post-1965 when investigative literature was published. Maria's case is very similar to the facts of Maguire and Harland and Wolff, which will be examined in some detail. Concluding thoughts are the BBC is likely to be liable in both claims, as courts for tort law cases don't like to leave claimants without compensation when a wrong has occurred, and the duty of care, breach of that duty, causation, and no defence is evident. For actionable damage for Tony, the first round of the tort law test for personal injury, the Rothwell test of there needs to be a deleterious change caused by physical harm making you appreciably worse off needs to be satisfied, which it does. Even though none of the stage hands swept the stage, the BBC is liable through vicarious liability. Lord Justice Scarman in Rose and Plenty states the principle of vicarious liability is one of public policy, to hold employers liable. Duty of care, the next element to be established. Usually there is no liability for an omission, such as stage hands failing to sweep the stage, but in Stoven and Weiss, unless there is a special relationship. The close relationship between employer and employee is sufficient to justify an exception to the omissions rule, state Clerk and Linsell. Under the Health and Safety at Work Act 1974, Sections 1 and 2, there is a duty of every employer to ensure the safety and welfare of all of his employees. Therefore, the duty for Tony has been established. Breach of the duty is the next limb of the test. Nolan, in his article Varying the Standard of Care, states the reasonable person test is the objective standard for measuring a defendant's conduct, and there must be a sufficient probability to lead to a reasonable man to anticipate the harm from Bolton and Quantum. Therefore, the breach is satisfied as a reasonable person would have cleaned the stage. Causation. Firstly, factual causation. But for the BBC's inactions, would Tony be blind and unable to continue dancing? The answer is no. The harm wouldn't have occurred but for the breach, which is established in Barnet and Chelsea and Kensington Hospital Management. Secondly, legal causation. Remoteness of the damage is looking for the reasonable foreseeability of the harm from the Wagon Mound case. In Robertson and Post Office, because the Post Office could foresee some type of damage, they were entirely liable. Therefore, if it is established the BBC could foresee some type of harm, they will be liable. However, there is a possibility of novus actus interveniens from a third party, Dr. Riff, if it is completely unforeseen and unlikely to happen. Although Dr. Riff performs Tony's surgery competently, but if he fails to disclose the risks of the eye drops to Tony, it could be an intervening act which breaks the chain of causation. In Montgomery, Lady Hale introduced the materiality test for medical professionals. Doctors must ensure patients are aware of material risks, such as the worsening eyesight, and if not, there will be a break in the chain of causation. Defences. Contributory negligence is now only a partial defence since the Law Reform Contributory Negligence Act. There needs to be fault on behalf of the claimant and a causative link between the claimant's actions and harm, leading to a reduction in damages according to a relative level of fault. I'm not positive this argument will hold up in court, as it is difficult to prove that Tony was able to see the small stones when he started dancing. Therefore, the argument of novus actus interveniens is much stronger. Volenti non fitinuria. This defence will also be difficult to establish, as it needs to be proven that Tony not only saw the stones but voluntarily agreed to incur the risk, which is also unlikely. Thirdly, illegality. Because the claimant has not committed an illegal act, this defence is also not applicable. Concluding points. It would be worth arguing there was an intervening act of Dr. Riff. It is found he didn't warn Tony of the associated risks with his treatment, as he, rather than the BBC, could be liable in personal injury. This course of argument may be problematic due to the court wanting a very high threshold for negligence in medical cases against doctors to prevent floodgates opening. The amount of compensation to be awarded to Tony is said to be the sum of money which will put the party who has been injured in the same position he would have been if he didn't sustain an injury. Lord Blackburn in Livingston and Raw Yards. In monetary value, this will be between £42,000 and £118,000, potentially more as he is unable to continue dancing. Maria could sue a ballet company under actionable damage for personal injury in the tort of negligence. As previously stated, there needs to be a deleterious change from Rothwell, and the skin cancer satisfies this. In the duty of care, the general principle from Dorset Yacht and Home Office for third parties is, a man is under no duty of controlling another man to prevent his damage to a third, unless the special exception is met, leading to a duty of care. The defendant may be held liable in negligence if they negligently cause or permit to create a source of danger, and it is reasonably foreseeable to third parties, as per Lord Gough and Smith and Littlewoods. This can be countered, though, for the BBC with the more recent case of Michael and Chief Constable. This is because the murder was not under the control of the police, so there was no liability seen. In Michael, it was also noted the established method of the court involves examining decided cases to see how far the law has gone in order to extend liability to a new situation, and if it's socially justifiable. I believe that because this case is dealing with asbestos-induced mesomelanoma, a cancer, there is a high probability the court may extend liability. Breach of the duty of care. The reasonable person test from Blythe and Birmingham Waterworks Company is whether a reasonable person would have knowingly allowed their employee to contaminate others with asbestos. This could be problematic to discover, so we need to look at other objective standards such as timing to establish the duty of care. If the harm cannot be reasonably foreseen, such as in Williams and Birmingham University, there is no breach. But the BBC could argue this point, but with the journalist discovering asbestos, I believe the BBC ought to have already been made aware of it. Maguire and Holland and Wolfe considers the element of timing in relation to asbestos cases. Mrs. Maguire also had secondary exposure to asbestos dust. It was found that it was not reasonably foreseeable between 1965 and 1960 that Mr. Maguire's employment, that a wife washing the clothes of a husband who had been exposed to asbestos would lead to her suffering personal injury. The Chief Inspector's report for 1966 then stated protection must be provided not only for men carrying out the process, but also for other persons in the confined space. It is here that the consideration for others begins, and the Maguire case only failed because of the timing the wife was exposed to asbestos, because we were scientifically unaware of the impact. In Gibson and Babcock, damages were awarded after showing the injury to the wife occurred post-1965. Ultimately, I think there is a breach of duty of care because Maguire and Babcock cases are so applicable. The William case is not as relevant as Maria was exposed to asbestos when the BBC should have known the risks. Causation, factual causation. There are multiple possible defendants who have caused Maria's mesomelanoma, the BBC and the London Ballet Company. Mesomelanoma could be an indivisible injury as related to mesothelioma, so the Fairchild conditions need to be examined. There must be an evidentiary gap, the defendant materially increasing the risk of harm, and the harm is caused by the risk the defendants created by acting in the same way. Maria succeeds on all of these conditions. Maria cannot pursue a claim in joint and several liability, however, as this is only for mesothelioma. Whereas, a claim under proportionate liability established in Barker could be able to claim against the BBC for a proportion of her harm they caused in relation to the risk they created. Because Bernardo worked for the BBC for all of his employment and whilst at the London Ballet Company, I believe this will be a large proportion. Finally, legal causation. The remoteness test again for the reasonable foreseeability of the type of harm. The likelihood is yes. As already established post-1965, employers were expected to be aware of this type of damage. Any defences? No, I don't believe there are any defences under contributory negligence, voluntary non-fit inuria, nor illegality, because Maria satisfies none of these conditions. To conclude, anyone with asbestos-related injury must bring their claim within 3 years, and if Maria fails to do this, she'll be unable to make her claim. Underpinning the rationale behind tort law is distributive justice and welfare considerations. Beyond the two parties, the court wants to make a socially desirable outcome, notes Robertson in Constraints on Policy-Based Reasoning. Thus, if other victims of mesomelanoma have been in the same situation as Maria, the court needs to protect society. And to object to this argument before it is even made, the BBC could, however, be persuasive in a case for floodgates being opened, allowing too many people to sue, therefore creating too large of a burden on the court. Ultimately, though, I agree with Lord Bingham in Fairchild, as when harm is committed, it is unreasonable to leave the claimant without a remedy, even when we don't know who did it, because it is such an important societal issue as related to mesothelioma, and it's a cancer. Henceforth, I believe compensation will have to be paid to Maria and to Tony.